When I started practicing, I won't say in which year, we would often go out to, physically go to clients' locations to pick up documents, actual papers, right? And a lot of times I would go through files and they would almost be empty. There had been an attitude of, well, if there's no documentation of something, then it didn't happen. In this video, I'm going to tell you why that is not a really good strategy today. I'm Nancy Schick of Third Year Conflict Resolution. I'm an employment attorney and mediator based in New York City, and I've been talking about documentation because a lot of people have some very strange ideas of what is evidence, how it can be used, and whether you should be collecting it at all. So the number one thing you need to know is yes, you need to be collecting it anytime you think you may have to either assert a claim or defend a claim. What kinds of things do I see? I'm going to tell you three that I deal with regularly. It's timesheets. We see that a lot of employers don't want to keep payroll records and all of that. They'd rather just do salary and cut a check. And I see this a lot with domestic employers who maybe have a full-time nanny, elder companion, etc. They're paying a nice salary and they think that's going to be enough to make sure that they don't have to do things like pay overtime. That is not true. Second, I also see that people fail to form a written agreement memorializing the various terms of their relationship when they do business together. Then, if it's a long-term contract where you're going to be working on something for quite a while, what happens is memories are fallible. People think that they remember what they're supposed to be doing, or something changes during the relationship and they just go ahead and try to address it without going back to the terms of the contract. We end up with a breach of contract. A lot of that could be avoided with clear terms, at least the key terms. If you're not sure what that is, then you might want to click that link below at the end of the video and schedule a consultation. We can go through some of those key terms that should be in your contract. Third, one of the big issues that I see with businesses is they don't do all the follow-up paperwork. So after they have incorporated or formed a limited liability company, a lot of people use those terms simultaneously. They form a separate entity to hold the liability, but then they don't do all of the follow-up documentation. And we do, in a court case, what the courts call piercing the corporate veil. That means effectively you paid all that money to set up this separate entity, but because you didn't treat it like a separate entity, neither is the court. That insulation you wanted from liability attaching to your personal assets, that might not exist if you don't keep your papers up. If you're not sure if you're in compliance and keeping your documents the way you need to, again, click that link below and schedule a consultation. Of course, in the meantime, keep listening with your third ear for those hurts you can heal.